Modern Real Estate Practice, page 69. Co-owners. A share owned by a married couple can be transferred only with the agreement of both parties. No individual tenant may transfer the ownership of the entire property. When one co-owner dies, the tenant's undivided interest passes according to the descendant's will to the heirs identified by statute if there is no will, or by the terms of the descendant's living trust if one established prior to death. See Figure 5.1. Figure 5.1. Tenancy in common. A and B are tenants in common. A owns half the interest, B owns half the interest. B dies and wills his interest to C and D equally as tenants in common. So now A still owns half, C owns 1/4, and D owns 1/4. When two or more single individuals or couples acquire title to real estate and the form of ownership is not indicated, the new owners are usually determined to have acquired title as tenants in common. The tenants in common has become popular in expensive urban areas because it allows a multi-family dwelling to be sold to multiple owners without the need to convert the entire property to the condominium form of ownership, which may entail a lengthy and expensive approval process. The downside of a co-owner's tenancy in common interest is that it may not be as easy to sell as property held in a different form of ownership. Formation of a tenancy in common requires use of an attorney to clarify the terms of ownership. In practice, the problem of owning the right to use an entire property but having only a fractional ownership interest usually is resolved by agreement of the co-tenants to specify the part of the property that each will use individually and the part of the property that will be shared. In a residential property with 3 units, for instance, if there are 3 tenancy in common interest, each co-tenant may, by agreement of all 3, occupy a specified unit, with all 3 having the right to use all other areas, such as a basement storage space, an outdoor space, or an outdoor space. The agreement should also specify how responsibility for property maintenance, expenses, and taxes is to be shared. Unless all 3 units are very comparable, this is where any differences may be equalized, with the co-tenant who enjoys the use of the largest or most desirable unit paying a larger portion of the expenses. Joint tenancy. Most states recognize some form of joint tenancy in property owned by 2 or more people, whether married or unmarried. The distinguishing feature of a joint tenancy is the right of survivorship. Upon the death of a joint tenant, the deceased interests transfer directly to the surviving joint tenant or tenants. Essentially, there is one less owner. No formal legal action is required, although the death certificate of the deceased owner should be made part of the public record and a copy retained by the surviving owners.